Here at CSDA, we're excited to bring you all the latest on new laws impacting special districts. Thanks for tuning in to our new laws series. Come check out the latest edition, a quick interview with Mr. Gage Dungy of Liebert, Cassidy, Whitmore, talking about employment laws affecting special districts in the new year. We're here with Gage Dungy from Liebert, Cassidy, Whitmore. One of the things I love about Gage is that he's always really closely integrated with our lobbying team at CSDA, helping us kind of work through new legislation as it comes in, which really sets him up when those bills come into take effect in law. He's also constantly giving presentations to our members, I know, at a lot of our trainings, so has just a great insight for what it is to be a special district and the types of issues they face. So thanks for being here today, Gage, and thank you for participating in our 2025 New Laws series.
Hey, thanks, Kyle. It's always a pleasure to be of assistance to CSDA. I think what's interesting, just like every other year, we always see a lot of crazy new bills that come out of the legislature. The good news, I think, is this year there's not as many ones that are coming out that are having a huge impact for public agencies, including special districts. In the article I prepared for CSDA, there's two bills in particular that I think come to mind that I think special districts need to be aware of and start looking at. The first one's SB 399. This bill is aimed mostly at the private sector. It's called the Captive Audiences Bill. It says that we cannot require an employee to attend a meeting or mandate them to attend a meeting where there's going to be a message of a political nature or of a religious nature. Now, why this one doesn't have as much of an impact, I think, for public agencies is for a few reasons. First, we have the Establishment Clause. So meaning that under the United States Constitution, we can't endorse a religion as a public agency, so we shouldn't be having religious meetings of any sort anyways. On the political side of things, this gets a little bit tricky, though, because our role as public agencies, in essence, is to enforce public policy. Public policy is done in a political manner through the political process, through your governing bodies. However, this bill has a number of features in there that provides exemptions for public agencies that says it's not a captive audience if we're trying to promote public policy or if we're trying to enforce the laws as are written. So I think in a lot of ways it's something to be kind of somewhat careful of, but hopefully it will not have as much of an impact on public agencies overall. The other bill that I think is also important that I'm also talked about in this article is SB 1100. This involves requirements for driver's licenses. Many public agencies have a requirement, as do many employers, frankly, statewide, that an employee has to have a valid driver's license to work at a place of employment. What SB 1100 tries to focus on is not so much towards towards current employees, but applicants. If you have job postings, advertisements that say we require a driver's license, that could be unlawful if it turns out that the person's ability to do their job can be done without having to drive a car. Or it could also be done if you need them to drive somewhere, they could do it through alternative methods, such as a ride-sharing service like Uber or Lyft, a taxi, using the bus or using a subway or their light rail or something like that. So in that regard, it's focused on new applicants and doing that. The main important thing, I think, for public agencies, though, is to take a look if we require driver's licenses for our employees or applicants, why? If it's a pure clerical job, is it really needed? Now, I will say one of the things, too, this is also a bill, I think, that's primarily aimed towards the private sector as opposed to the public sector. One specific argument that the public sector may be able to make is that technically all public employees could be what we call disaster service workers. So even though their day-to-day jobs may not require them to drive if a disaster or an emergency happens, and we've seen this over the years. COVID was an example where we had a state of emergency, and we had to shift employees in a lot of different ways. Sometimes we have certain acts of nature, fires, floods that come in special districts, along with other public agencies, have to invoke their employees in a different manner as a disaster service worker. So there's an argument you may be able to require it there. But I would say on the whole, probably the best thing, the best practice to do is take a look at what are our job positions, which ones actually would require someone to drive, and if there's more clerical or office type positions that really don't, well, maybe we take that requirement out. But that's going to be more a judgment decision for those districts.
That's really helpful, Gage. Thank you. And I know that our lobbying team, particularly Aaron Avery, our state legislative affairs director in partnership with a coalition, was really successful in getting some amendments that helped to improve those bills that did pass and help to prevent a few much worse bills from going through. With regards to those two bills, whether it's 399 or the driver's license bill, so the captive audience bill. I love that name, captive audience, too. Anything that you think a special district, whether it's an HR director, a general manager, supervisors, employers out there, what ought we be thinking to get ahead of this before it goes into effect January 1 or as we start working through it in the new year?
I think on that, so SB 399, that first bill, the captive audience bill, not sure there's a whole lot to be concerned about, except maybe if there's any kind of political activities taking place at within the special district, and you may have rules, we want to enforce those rules to limit that kind of activity or limit where we're forcing an employee to be part of that. That's probably the biggest area. I don't think it's going to have as huge an impact. I will say, going back to the driver's license one, SB 1100, that's one where I think, even though it's not entirely clear how this is going to apply in the bigger scheme of things for current employees as opposed to new applicants, it's probably better for an HR manager, for example, HR director, take a look at your job positions. Do we require everyone to have a driver's license? And maybe take a harder look at why. You know, and if there's something that we can't really justify or hasn't been needed or perhaps it's outdated, obviously I would tell you that it's good to look at your job descriptions as much as you can, even on an annual basis. I have clients over the years who will send me a job description and it looks like it was mimeographed over and over again back in on a typewriter back in 1972. Odds are that's probably changed over time. So it's just good to make sure and update those things, and it's a good opportunity to take a look at that.
Excellent. Lastly, I wanted to ask you, I know there was a big court case, the Stone decision, I believe, that really could have a lot of ramifications, I would imagine, even though I know some of us maybe believed that it was the case to begin with, and we're pleased to see the outcome. What would you have to say in terms of what did that case decide, and what does it mean for us?
So the case you're talking about is a California Supreme Court case called Stone v. Alameda Health System. This just came out here, I believe it was either September, October time. Great case. It's a great case for public agencies for a few reasons. First of all, we have what's called the California Labor Code. And a lot of the California Labor Code is a public sector agencies such as special districts are exempt from. But it's not very clear, and a lot of those labor code provisions were written back in the 1930s. They haven't been touched for several years. You know, they're off and on. There's some more express exemptions. There's others that aren't. Then we have what's called the wage orders. Those are based off regulations, based off the labor code. And then the question becomes, what does actually apply to a public sector agency? So we know that a number of provisions that are in what I would call California's wage and hour laws don't. We don't have daily overtime. We don't have double time. Meal and rest periods, for the most part, with a few exceptions, don't apply to the public sector. And we've seen that. However, the application of other things, or what's considered to be a public sector agency, hasn't always been so clear, and the courts, especially the lower courts of appeal, have been all over the place on this. There was a special districts case, I think it was Johnson versus Arvin Edison Water Storage District back in around 2008, 2009. Great Court of Appeal case from the 5th District that said, hey, unless it's written in the labor code, doesn't apply to public agencies, meaning it has to be expressly stated. Since then, though, we've seen other courts of appeal go in different directions. Never got to the Supreme Court until this case, the Stone case. And the value of it is the Stone case, for the most part, upheld what that earlier Johnson case had said back in the late 2000s and said, no, this is correct. The labor code does not apply to public agencies for the most part unless expressly stated. And it's great to see that because it provides a lot more clarity as to how we apply the labor code, what doesn't apply. And when the labor code doesn't apply, just so we're clear, we still have federal laws, what's called the Fair Labor Standards Act, other kinds of things that do apply to public agencies, but it provides a lot more clear direction that assists on that. The other kind of odd issue is that Alameda Health Systems was technically a public agency that was an offshoot, I believe, of the County of Alameda. It wasn't clear if they were a municipal corporation or a special district, and the court very clearly said that that applies to anything that actually is part of a public agency that's enacted by, I think this was through the Health and Safety Code, and so is not, it does not mean that they're somehow carved out as compared to other public agencies. Great case for special districts, great case, I think, for public agencies overall to clarify what wage and hour laws do or don't apply.
Excellent. Well, I think we're all going to want to take a closer look at your New Laws series article, which will be available at csda.net and in your e-news. And thank you all for joining us, and thank you, Gage.
Great, thanks, Kyle. Pleasure to be here. Pleasure to assist.